Good afternoon, everybody. My name is David Lafkas. I'm the patent and trademark attorney here at Eureka Ranch, and welcome to today's webinar. Today's kind of a specialty one. Rather than doing different segments in innovation engineering as a system, we're just going to look very closely at one little aspect of one of our areas, which is intellectual property, and we're going to talk about what is patentable and what is not, to give you kind of a general overview. Keep in mind, obviously, I am an attorney, but don't take any of this as legal advice. If you have any particular questions about any of your specific patents, trademarks, copyrights, I really do suggest that you make an appointment, meet with a patent attorney, and ask them. But happy to give you some general information here, some education, so that you can go in and be even smarter before you meet with your patent attorney or patent agent. As we go today too, I want to make sure that you all know that using GoToWebinar, there is a chat feature down at the bottom, and if you have questions as I'm going through this, feel free to type some in, and we'll try and get to those at the end. I'll probably keep the flow going and not break the momentum with the questions until the end, but feel free to type them in there as they're coming to you as we go through. So, first of all, intellectual property is an umbrella term, actually covers several different areas. It covers patents, copyrights, trademarks, trade secrets, and each of those protect different things. So keep in mind within your products and services, you might actually have protection in each of those areas. So you could have an invention that's patented, you'll have a trademark for how it's named, maybe a slogan for it or color that would be under the trademarks, and then the copyright, maybe the text that you actually have on the packaging, or any of your associated web pages or anything like that you might want to get a copyright on. So keep in mind that you don't have to have just one type of these, you might want to have several, and in fact, we'd highly recommend it. Now, why are we talking about patents? Well, here at Eureka Ranch and with innovation engineering as a whole, we find that patents are the standard for what's meaningfully unique. So that's the threshold that we are always reaching for with any of our products and services that we're working on. And so it works really well with what the standard of patentability is at the U.S. Patent and Trademark Office, because to have something be patented in the United States, it has to be meaningful. It's got to be useful. So it's got to solve a problem, and it has to be unique. So it has to be non-obvious. It has to be more than just a logical leap based off of everything else that's already out there in the world. So being patentable and meaningfully unique works really well. And getting a patent in the United States really gives you a monopoly. It's kind of a government-backed one. The government's not going to step in and stop people from stealing your inventions, but they will kind of support you in so much as if you go to court, they will say, yes, you have a patent, but you have to go after it yourself. There's no such thing as patent police. But it gives you the right to exclude others from making, using, offering your invention for sale, etc., within the United States. So you can't just get a patent in the United States and then also expect that people won't copy you in Canada. For example, if you want to get protection in Canada, you got to go up to Canada. Or if you want to go to Europe, you have to get a protection over there. So keep in mind that patents protect you just in the region that you've gotten the government to approve your application and issue a patent. There's no such thing as an international patent either, so please keep that in mind. Even in Europe, they'll view it for the entire European Union, but you then have to pick which countries you want to get protection in. They can get expensive very quickly. So keep that in mind. Wherever you go, that's where you get the protection. Now, on the flip side of that, one of the things that we do teach here at the ranch is that going to other countries and looking at their patents and other inventions in those countries that are not protected in the United States is a great way to get stimulus and build upon those inventions and maybe get protection in the United States for improvements that you're making upon it. Of course, you always want to make sure that they don't have it patented already in the United States, but great area for stimulus. Now, there are three different types of patents: utility, plant, and design patents. Now, when we talk about utility patents, that's what most people think of when they hear about patents. Right now, in the United States, there are about 9 million different patents that are utility patents. There are also plant patents, which protect asexually produced plants. There's only about 50,000 of those. Where you might see that most often these days are kind of hybrid plants, fruits, and vegetables. So Next time you go to this grocery store and you're in the fruits and vegetables area, you might see what are known as grapples. And those are kind of a cross between apples and grapes. That would probably be protected under a plant patent. Then we also have design patents. And design patents are a quick way to get protection just for the way something looks. It's not going to give you protection for anything that it does or how it's made, purely the way it looks. And here's an example of one. I'll go to full slide here for you. And this is actually a design patent for a pretzel. And you know it's a design patent by looking at it right away, because right at the top it does say design patent, but next to that with the patent number, it starts with a D. And so anytime you see a patent number that starts with a D, automatically think, hey, that's a design patent. It's only going to protect exactly the way something looks. Now you might ask yourself, why would I just want to protect the way something looks? Well, there are a lot of areas where this is really great to do because you can very quickly say that you're patented, because usually the patent office can look at these in as little as 6 months. And then these are actually growing in popularity because design patents actually helped Apple win its court cases against Samsung because the appearance of the Apple products were protected with a design patent and distinguished themselves beyond just the utility aspects of their patents. And keep in mind, just as I was talking about intellectual property as a whole, where you can get protection for copyrights, trademarks, patents, etc., all for the same thing, you can get a design patent and a utility patent for the same thing, and I would strongly recommend it. Okay, and then there are some standards for getting protection for these things. Now we're going to focus just on utility patents because that's what most people think of whenever they're getting a patent in the United States. And the 3 standards that you have to reach in order to get a patent in the United States are utility, novelty, and non-obviousness. Now I'm going to run through these, the last 2 rather quickly, and then we're going to focus on the utility aspect because that's really what tells you what can and can't be patented in the United States. So the novelty standard means that there's no single thing out there exactly like your invention. And when I say exactly, I mean exactly. The patent office is going to look at how you define your invention. And if you say that you've got, say, a fork and it has 5 spokes coming off of it, and the closest thing you can find has 6, well, that's different enough that you can prove that you have novelty over that other one. It's kind of a lower threshold and something you can do on your own. I strongly recommend, before you ever meet with a patent and trademark attorney, do your own research in advance, or else you're going to be paying for it literally. So go and, obviously, you've got our websites of invention blueprints, which is a great place to be searching for patents. Go and see what other things you can find in there, and you can usually do your own knockout on what's novel or not. Now the next one's a little bit tough. And this is the non-obviousness standard. This is very, very subjective. At the Patent and Trademark Office right now, there are about 7,200 different patent examiners. And as I like to tell most people, that also means there are about 7,200 different standards of non-obviousness. Now, that might not be fair of me to say about the Patent Office. There's a lot of great people working there, but everybody has a little bit different idea about what they think really makes your invention different from a non-obviousness standard. And what that really means is your invention just merely a logical leap based off of everything else out there? So the example I gave before, if you have a fork with 5 spokes, a 6th spoke really isn't probably going to do anything different on a fork. And so the Patent Office would say as much. And you've got to prove that that's not true. And yours has to be more than just merely combining different inventions that are out there. So what you want to do in this area is really prove that yours has a critical aspect, or you're doing something that everybody said you should never do in this area. And the example I always give in class here at Teaching Innovation College is the example of one of my clients. This goes back about 10 years, where he worked in the Kevlar industry. So aramid fibers is what they're really called. And everybody in this area always knows you never, ever put that material into a washing machine with like detergent. He was curious why one night. And so he went home, threw some in the washing machine, with some just Tide detergent, and what he found is that it actually took the fibers and pulled them tighter together, and it made that Kevlar material not only anti-ballistic, but also anti-stab. And so it became one of the first products out there that was both anti-stab and anti-ballistic. So he did something that was non-obvious and that everybody said, don't do it. He did it and improved the product. And he was able to get a patent on that. Now, let's really focus on the utility standard, because this is what decides whether or not you have anything patentable to begin with. So then, before you even get into the novelty area and non-obviousness, you really need to fall into one of these 4 areas. It needs to be a machine, an article of manufacture, a process, or a composition. Now, I will tell you the Patent Office has some very strict standards on some of these, so we're going to go through and give you some broad examples on each of these. So for the machine, I'm not going to go through exactly what the Supreme Court here has said, because I don't want to bore you there, and it's up on the screen. Feel free to read it. But basically, a machine is something that's going to perform a function. It's going to make something, it's going to change something or move something. I'll give an example there of a vacuum cleaner. It's going to pull the dirt out of the carpet for you and make your carpets cleaner. It's doing something. Other examples there, steam engines, sewing machines, TV sets. You guys know what a machine is. Well, if yours is doing something or making something, it's going to fall into that area. That's awesome. And then you can move on and deal with the novelty and non-obviousness aspects. Article of manufacture is something that's tangible and usually more static parts. It's not making something necessarily. Think more like a hammer or ceramics, crowbars, chairs, gloves. Something you can use, but in and of itself, it really doesn't do anything. It might be made by a machine. The next one, a process. It's something for doing something, making something, transforming something. I give an example, I show a picture there of somebody building something. So maybe part of their protected process is actually building something and having to turn that nut and bolt there. Next, we have compositions. Now, I used to do a lot of patents in the chemical area because that is my background. And so, for example, I did a lot of patents for Xerox back when I was with my previous law firm. And basically, I did a lot of these in the chemical area, and this is where you're going to see it most often. And so it was combining 2 or more ingredients together. So think of like new chemicals, pharmaceuticals. You're going to have a lot of things in this area, beverages, and maybe some food things as well. So keep in mind, you want things to fall into being a machine, article of manufacture, process, or composition. But of course, we've got some judicial exclusions that have, over the years, they've said, look, these are things that we just flat out say, don't fall into one of those areas, so don't even go there. You cannot patent these. And so what are they? Laws of nature, natural phenomena, and abstract ideas. So basically, anything that's out there already that's occurring in nature, you cannot protect because essentially everybody needs it. So laws of nature, gravity, you could not go and patent gravity. We all need it, we all use it, and it just occurs. You have no control over it anyway. Natural phenomena. So, I'm drawing a blank all of a sudden, pardon me. But basically anything that would just be growing in the yard, you couldn't all of a sudden patent that as, say, a new grass or something. Well, it just appeared there on its own. You didn't do it. And then abstract ideas. You couldn't go to the patent office and say, hey, I'm going to protect a flying car. The patent office is going to say, that's nice. That's an abstract idea. How does your car fly? You've got to make it real. You can't just make things up or protect things without knowing how they actually do it. Now, the reasons for these exclusions are basically because these are things that everybody needs to be able to use and do. And mental processes and algorithms fall into this as well. And one of the things that I've dealt with quite a bit during Innovation College, because our black belts have to learn to write their own provisional patent applications, is using the word algorithms. And I know they don't mean it exactly like the patent office means, but I would strongly recommend not using that term even in a patent application because the patent office will look at that and it's a quick way for them just to kill your invention without truly understanding it. So if you're actually doing an algorithm, talk about it more as a process or method of doing something. That being said, they're supposed to look at your invention as a whole. So you could say, hey, part of my process uses an algorithm, but try not to say that your entire invention just is an algorithm, or else the patent office can very easily say, hey, we're not going to go there and kill your invention. Because they've got a backlog right now of about 1 million applications. So if they can kill some quickly, they definitely will. So a couple other examples of things that are not patentable. You can't do paradigms from marketing software, transitory electronic signals, so computer readable media and such. Patent office just said no. Forms, literary works, compositions of music, and compilations of data, cannot patent them. The patent office has flat out said that, and frankly, those belong in the copyright area anyway. And if you want to know more about how to do your own copyrights, a look back a couple weeks ago, we did a webinar on how to file your own copyright application. It's really easy to do, and I recommend that you do that on your own, but protect those that way, not with patents. Forms of energy, so data packs over the internet, can't do that either. Ideas, we talked about that. You got to make it real and tangible, even if it's just writing it down and explaining it. Step by step or part by part, explaining how everything goes together, that's going to make it real enough for the patent office, but not just an idea of, hey, I got a flying car. Tell me how the car flies. And then, and this is a big one that I've really been pushing with a lot of people recently, is you can't patent benefits. You can only protect features. So what are the parts that make up your invention? What are the exact steps that go into your process? That's what you protect with a patent, not the benefits. So keep that in mind. Just always focus on the features, because that's what you're going to end up protecting. A couple things that you can patent, the courts have said. Non-naturally occurring, non-human, multicellular living organisms, including animals. So if you were to create in a laboratory some non-naturally occurring multicellular things, you can patent it. Now, of course, we don't want you doing anything dangerous, creating any new viruses or anything, but if you did, you could protect them this way. Of course, you still might have to go through a whole nother step of actually getting the ability to use it. So this actually happens quite a bit in the pharmaceutical area, where they'll create some new multicellular living organisms, but then they have to go through FDA approval. So you can have the patent, but you might not be able to actually practice it yourself yet until you go through other hurdles. You can also process using a computer where something changes or moves form. That you can protect. The patent office is really coming down hard on these, but you can still technically do it. And same with business methods, and you've probably heard that term. Some people also call some of these software patents. The Supreme Court has flat out said that these are patentable. It's really tough to get them through the patent office right now, because they're saying a lot of those business methods that are going on fall more into the abstract idea area. So there's a kind of a fine line there, and so if you're going down this route of business methods or software, which are protectable, that's one area where I would strongly say make an appointment with a patent attorney and talk to them about it, because you could end up saying the wrong thing in one of those patent applications. Whereas if you're just doing the typical machine, article manufacture, and process stuff, you'd probably be okay doing that on your own, doing your own provisional, but you might want to meet with a patent attorney about those others. And so as you're reaching to be meaningfully unique with your products and services, focus on falling into one of those top four, whether it's a machine, article manufacture, process, or composition, and don't go down the road of natural phenomena, abstract ideas, perpetual motion machines, etc. Those you cannot protect. So, and we'll see here if we have any questions. And we do have one, but if you have any other questions beyond today, obviously, always feel free to shoot me an email. I'm here to help. Just David at Eureka Ranch, shoot me a note and just say, hey, saw the webinar, had this other follow-up question. Or can you help me find somebody in my area that I could talk to and help me write a patent application? Happy to put you in touch with somebody. So let's see, I got a question here. Can you patent an app? So obviously that's a growing area right now of interest with a lot of people. There are like 1 million apps now for iPhones and iPads, etc. Technically, yes, you can get protection for those. It would fall probably more into the business method software patent area, and so kind of be more of a process of doing something. That's how I would write something like that, and it's a process of doing something on your iPhone or iPad. And you'd want to talk about exactly what you're trying to do. So it might be a matter of if you had one for, well, like here at the ranch, we have one for our yellow cards. And so it would be a matter of talking about how to fill out the yellow card itself on the app, what happens when there's a button there where you flip the yellow card over, and then the connection it has to our system where then it posts it to your portal. All of that step-by-step process is what you would end up protecting, and it kind of, at the end of that process, it would be like, and by the way, it's on a mobile internet-connected device. That's how you would do that. Okay, and then I've got here another question just about, can you protect a name? Yeah, but that you can protect names for your products, but that really falls more under the trademark area. So names, slogans, logos, colors, all of that would fall more under the trademark area, not the patents. The patents are just going to be products and services and how they're combined and put together. So that seems to be it for right now, question-wise. Again, if you have any other questions, feel free to drop me a note at any time. And while I still have your attention, I just want to remind people that we've got some upcoming events. We have the Innovation Engineering Executive Program coming up about a week here at Eureka Ranch. It's always a great way to just get a general overview of innovation engineering. And obviously, we're very happy to come to any company and do private ones as well if you would like. Just reach out to us and we'll happily do that. And then Innovation College is coming up first week of December, and that is where you get really hands-on with all 48 skills. It is fun, it's educational, and you will learn so much more about patents there too, where by the end of it you'll be drafting your own provisional patent application that you actually file with the Patent and Trademark Office. So I think it's pretty awesome. So thank you for watching today, and again, if you have any questions, drop me a note at david@eurekaranch.com. Thank you.